everybody. I was trying to remember whether this is my fourth or fifth year presenting here at Vega, and I have to admit that I have lost track.
That's a good thing.
I'm happy to be back before a familiar and friendly audience. And this time I have Nakia Matthews with me, who is the newest addition to the legal ethics program at the DC Bar. And sadly for Nakia, she's been here for 2 years now. I'm the second most junior member of the legal ethics program, and I've been here for 8 years. So she's probably going to be carrying that title for a very long time. So many of you have probably seen us present before. The best presentation is conversational in nature. We invite people to push back, ask questions. I told Asia to go ahead and unmute people or give people the ability to unmute themselves. So please feel free to take advantage of that, or if you prefer to, shoot us a message in the chat, and we'll try to keep an eye on that as well. So I'm going to move along. Can we get to the very first slide, Asia? Great. And let's go right ahead here. Actually, I'll just make a quick note that Rashi and H are actually going to be participating with Nakia and me today. We're going to be sharing our thoughts on various ethics issues, and you've got the benefit of having both the legal ethics perspective and the government ethics Vega perspective as well. Next slide. So this is something that's going to look familiar, but I do like to reinforce the resources the DC Bar has for all of its members. And it's somewhat unusual for us to be talking to a group of lawyers who are presumably all members or pending members of the DC Bar. We have a lot of ethics resources available, and they can all be found on our website. You'll see it's, dcbar.org. We've got the rules of professional conduct that we're talking about today. We've got the legal ethics opinions, the formal ethics opinions that are published by our legal ethics committee. We have contact information for the confidential ethics helpline at the DC Bar, where you can call and get informal guidance. And this is a resource in particular that I would encourage you to take advantage of. Your membership dues have purchased free access to Hope Todd, Saul Singer, Nakia, and me. And we pretty much pick up the call between 9 and 5 on weekdays. And we are happy to address ethics questions on the fly, or consult among ourselves if we need more feedback in order to answer your questions. So whether it's a pressing and urgent problem, whether you're just wondering about a situation, if you're going into a consultation with a colleague or your supervisor and you just want to have a little bit more grounding in the rules, or try to figure out if your concern is a real concern, or if it's not a concern, or what kind of problem you're grappling with, please do take advantage of it. We're happy to talk. And of course, we have other resources such as our interpretation of the rules, a number of articles and short question and answer format type pieces that we've published that are linked on the website. Vega, I know that I think Asia is regularly answering questions as well with Rashi. So of course you've got that availability as well. And then you've got your own DC government ethics staff that you can talk with. So just reminding people of the resources. The other thing I'll mention really quickly, again, it's part of your membership benefits with the DC Bar. Within our program, the Regulation Counsel Department of the DC Bar, we have the Lawyer Assistance Program, which is truly a wonderful program. We've got a number of trained counselors that help lawyers deal with crises, whether it's a big crisis, a small crisis, work-related anxiety, personal life-related anxiety. They're really a tremendous resource. And again, it is confidential and free and available to you as a member of the bar. Another issue that they deal with very competently is, if you're having a problem with a colleague and substance abuse, something like that, and you need some help figuring out how to reach out to that person, what resources are available to them as a member, if they are also a member of the DC Bar. They have a really good program that will help educate you as a DC Bar member on how to reach out to a colleague or address a problem that's arisen at work. And the last thing I'll mention is the Practice Management Advisory Service Program at the DC Bar. Again, probably not as relevant to you in your day-to-day work with the DC government, but if you ever do end up leaving the DC government, opening up your own practice, opening up a consulting firm, it's a tremendously helpful resource. So next slide, please, Asia.
Erica, really quickly before I move to the next slide,
Sure.
someone mentioned in the chat that they see gray boxes blocking the slides. So I think that's me. I'm the host of the presentation, and what I'm doing is, I think that's the participant box as I am transferring folks over from attendees
I
to
see.
panelists. So I'll try to keep that out of your way as much as possible. I'm just checking it every couple of minutes to see who entered so that I can make them a panelist so that they can unmute themselves. So I apologize for that.
Got it. And if it's making them a panelist, it's a problem, feel free to skip that. I see it too, and I'm just working around it so far. So
okay, all right.
Good.
Next slide. Here we go.
Great. So when we're talking about the ethics rules, a few baseline statutory interpretation rules that are always important to remember. First, they govern the conduct of lawyers who are admitted to practice in the District of Columbia. They almost never govern the conduct of lawyers who are not admitted to practice in the District of Columbia unless they have somehow otherwise submitted themselves to the jurisdiction of the DC Bar and the Office of Disciplinary Counsel. For example, by entering an appearance pro hoc vice or something along those lines. This idea of permissive versus prohibitory is important to keep in mind. May, should, or shall. The rules are all written in those basic terms, and of course, only a failure to comply with an obligation or prohibition imposed by a rule is going to the imposition of discipline. The other thing to remember, again, an example of an aspirational rule as opposed to a mandatory or a prohibitory rule would be, for example, our Rule 6.1 on pro bono conduct, or doing pro bono work, contributing money to a cause that promotes access to justice. While we strongly encourage members to donate their time or financial resources to these causes, it's not a hard and fast requirement, and it's not going to become the basis for the imposition of discipline. And another way to think about this issue is the rule setting a baseline, below which your conduct cannot fall, and the best example I can come up with that is Rule 1.1. Most lawyers are always conducting themselves at a level that far exceeds that baseline that's required by Rule 1.1 and their duty of competence. But that stands in contrast to a rule like 4.2, which is the no contact rule for represented parties. A lawyer who is trying to be an advocate, an effective and zealous advocate for their client, might very well be obligated to get all the way up to that Rule 4.2 line and make sure that they are speaking to the people whom they are authorized to speak with on behalf of their client. So it's, very different ways of interpreting those rules, and it really affects the way we evaluate different situations and how we give guidance to people. So it's not an easy thing necessarily to understand, but a little bit of familiarity with the rules can help. Last point I'll make here is that the rules of professional conduct are rules of reason, and this is a rule that we turn to quite often because the rules are broad. They don't fit every possible situation, right? There are scenarios that sort of fall in between the cracks, or it's just unclear whether they're really subject to the prohibition of a rule in certain circumstances. And oftentimes the best thing we can do is say, look, here's what the purpose of the rule is. It's designed to push lawyers to conduct themselves in this way in these circumstances. If your circumstances look pretty close to that, even if they're not exactly in there, many prudent practitioners would follow the guidance in the rule, even if they're slightly outside of that. And then, of course, there are situations where you might argue that the other way. But don't discount the value of being reasonable and taking a prudent approach to the rules. All right, next slide, Asia. So based on what I've just said, this probably will all seem automatic. These rules are not, they don't exist in a vacuum, right? You are all subject to court rules, federal and state law. I think I could add to that any agency rules or guidance. There are other sources of law or policies which may or may not guide your conduct. So you want to make sure you're aware of that. We do our best to be aware of, things like the post-government restrictions on employment, things like that. But as lawyers, as professionals, it is always wise to make sure you're paying attention to any specific rules that might govern you outside of the rules of professional conduct. So that's just another way of saying that substantive law might guide your ethical conduct. And of course, what it comes down to is making sure you're tracking the prohibitions and the permissiveness appropriately, right? You basically need to make sure that you don't have a prohibition from either the substantive law or from the ethics rules in order to conclude that you can safely do something. So I think with that, we are getting into the hypotheticals. And the one thing I'll mention as I'm getting started here is that these hypotheticals are truly meant to get us into the rules. It's possible to argue, what the appropriate answer should be, and they can vary based on facts. So again, if you want to challenge our answers, if you want to suggest an alternative hypothetical or push our analysis a little bit, please feel free to do so. It makes it more fun and exciting for us. So I'm going to jump in and do number one here. I've got my blue square here. So Charles, lawyer in the general counsel's office at the DC Department of Employment Services. Before becoming a lawyer, Charles was an accountant. In addition to his employment with the DC government, during tax season, Charles operates a tax preparation business. He only takes a handful of clients, many of whom have been with him for years. However, he does occasionally take on a new client. So the question is, may Charles operate a tax business in addition to his government employment? And we've got 4 possible answers. No, because outside employment is completely prohibited. Yes, because it is not prohibited by the DC rules of professional conduct. Yes, as long as he complies with laws regarding outside employment and the DC government employees, or both B and C. And if you want to use the chat function to shoot us answers, we will start looking at that. Who wants to be brave and start with an answer?
I see someone, we got C.
All right.
We got a bunch of C's. Someone said D. Someone answered both B and C.
Okay. Excellent. And for some reason, I don't know if I'm looking in the right spot. I guess I'm looking at Q&A and not chat.
Yeah, they're answering in the chat so far.
Okay. All right, good. All right, I'm going to see if I can switch that over just so I can keep this live. All right, that's great. So why don't we move ahead to the next slide here? All right, you're right. I'm starting to see them now. So D is the answer that we were going for here, and which of course is both B and C. So in other words, you've got to make sure it's not prohibited by the DC rules of professional conduct, and it appears that he's complying with the law regarding outside employment in DC. So what are the rules that really govern here? From the ethics perspective, there's a couple of things he needs to be thinking about. First of all, rule 7. So this is the rule that talks about what limits a lawyer faces when the lawyer is engaged in law-related services. And if a lawyer who works for the DC government wants to open up a bakery on the side, odds are that lawyer can do whatever he wants with respect to his bakery, right? It's simply not related to the practice of law in any way. There's no reason to think that anyone who walks into a bakery is expecting to get legal services, even if they recognize that person as an attorney. There's no confusion to that person who's engaging with the person in a completely non-law related services. But if you open up a tax preparation business, right, and someone looks you up and says, oh, well, you're a DC government attorney, I'm getting a lawyer to do my taxes. Or Charles Loomer is mentioning the fact that he's got a background, a resume that makes him especially qualified to prepare people's taxes. That's when you get into a risk that you are going to be subject to the rules of professional conduct, even with respect to your non-legal practice. So you'll see in the two subsections of the rule, it says you're subject to the rules of professional conduct if you are providing those law-related services in circumstances that are not distinct from the lawyer's provision of legal services to clients. So that would, for example, be the lawyer who has a solo practice as an attorney and then offers to do the client's taxes as part of the legal services. Or in other circumstances by an entity controlled by that lawyer individually or with others, if the lawyer fails to take reasonable measures to assure that a person obtaining the law-related services knows that the services are not legal services. So again, in this situation, he'd have to make sure he's telling people who come into his tax preparation business that even though he is an attorney, he's not acting as their attorney when he prepares their taxes, and furthermore, that they're not getting the benefit of the attorney-client privilege. So why don't we jump ahead to the next slide? All right, so rule 1.7b4 is always a consideration as well. And again, the issue here is that when Charles has two different sort of income streams happening, and in one case he's acting as a lawyer, right? He's acting as a lawyer for the DC government. He has to make sure that no conflicts arise. And the types of conflicts that could arise in those situations are not going to be concurrent conflicts of interest stemming from competing client matters, right? Because he's only acting as a lawyer in one capacity, and that is for the DC government. But he could potentially develop a personal interest conflict in connection with the work he's doing in his tax preparation services. And that's what he needs to be worrying about. That's rule 1.7b4. And what that says is that his interest in maintaining his business or working with particular tax preparation clients could somehow lead him to be a less effective advocate for the DC agency that he's working for. That is a waivable conflict, but it would have to be waived by the DC agency that he works for, and I'm quite confident that he's not going to get such a waiver. So he's just got to flatly avoid those types of conflicts. What does that look like in a tax preparation business? My guess is if you're Charles Loomer and Rashi or Asia comes in and says, hey, would you do my taxes for me? You're probably going to say no. No, I will not do your taxes. That would not be appropriate. There's a few other names I could pull out that would fall into that category, but in general, you're going to avoid those types of things, because if something goes wrong in that tax preparation, a service that you're providing, you've got a problem at work as well, and that's a no-go. So, anything else that Rashi or Asia that you would want to add with respect to outside employment and what the rules are?
Yeah, so as I read the hypothetical, a couple of things came to mind. Definitely outside employment, which is going to be codified in the district personnel manual. That's going to be rule 1807. And so there are several outside employment prohibitions. The outside employment can't conflict with your duties. It can't cause you to be mentally or physically unable or ill-equipped to do your district government duties. You can't use district government resources. You can't maintain a financial interest if the company or business is likely to do business with the district. So I think there are about 8 of them. And most people are, able to conduct outside business and have second jobs and stay within the bounds of the outside activity. But another thing that came to mind was disclosure. We have disclosure rules for district government employees. And so there is the initial disclosure, which is Rule 1805, which says when you come in, you have to disclose to your agency your past work. And so in this hypothetical, Charles, would say to the agency, I used to be an accountant. and describe what he used to do. And this is for purposes, screening folks against potential conflicts of interest. And then we have financial disclosure statements, the requirement to file financial disclosure statements. So based on Charles' disclosure in 1805, the agency may say, hey, these are the things that you can do, these are the things that you can't do. And then based on what you used to do and based on what you're going to do here now at the agency, we think that you should be required to file a financial disclosure statement. And if he is required to file that statement, he would definitely want to disclose the fact that he is still operating that he is operating his accounting services, and make that known and potentially put it on a public forum. I know everyone hates that, but he is going to want to make sure that he's compliant with our disclosure rules as well.
Great.
Only other thing I can think to add, just put the ditto marks under me for everything Asia said. Information.
Rashi, I don't know if everyone else can hear you, but you cut out for a moment for me. Yeah, it looks like folks are saying that they can't hear you. And I still can't hear you. I don't know if you're trying to speak. Sorry about that, Rashi. But you could always put your response in the chat if you want to.
Yeah.
Erica?
Yeah, so I'm thinking maybe we'll see if Rashi can jump back in, but in the meantime, maybe we should just keep going and
Yeah.
to the next hypothetical.
All right.
Okay, so the second question is, after careful thought and consideration, Charles has decided that he would like to leave DOES and join a law firm that provides representation in matters related to tax law and general civil litigation. Before Charles left DOES, he was detailed to the Office of Tax and Revenue for 2 months. After being at the firm for 6 months, he is asked to serve as second chair on a case where the client is challenging a tax assessment made by the District of Columbia. Can Charles serve as second chair on the case? So feel free to put your answers in the chat. I was having trouble seeing the ones earlier, so Asia, if you could.
Yep, let me pull it up right now.
I think I just saw a D.
I saw a D.
We got no and then a D. Yeah. So keep your responses coming, guys. Okay, here we go. A bunch of D. Someone said either C or D. D. Mostly D, a couple C's peppered in there.
Okay, so why don't we go to the next slide. And so the answer is C. No, because while the rules may allow it, the laws and policies pertaining to former government employees do not. And so from the rules of professional conduct perspective, and I guess I should back up and say this highlights what Erica was talking about earlier about the need to look at both the rules of professional conduct and in some instances, it'll be substantive law or statutes or other internal policies, because the rules of professional conduct here wouldn't prohibit the Charles taking on this case per se. So the rule that would control here would be Rule 111. And it's important to note that it's kind of a two-prong analysis. You're looking at both the personal and substantial participation, and the second part would be in a matter. And so it says a lawyer shall not accept other employment in connection with a matter which is the same or substantially related to a matter in which the lawyer personally and substantially participated as a public officer. And so things like general assisting or participating in general rulemaking or policies wouldn't necessarily be considered a matter. And so, you know, if you participated or if your work was primarily in that area, you would likely be okay. And then the second part is, did you participate personally substantially? And we do have a couple of legal ethics opinions, and we'll kind of go over those in the next slide that talk about that. There's nothing that is necessarily a bright line test. You know, sometimes you can send 2 or 3 emails, and the nature of your participation in those emails goes so concretely to that legal matter that it constitutes personal and substantial participation. So that's also necessary to note. Oftentimes people will say, well, I only, you know, sat in on one meeting. But if you kind of sat in on that meeting and it, you know, you revamped the case, or there was like, you really spoke to the heart of the matter, then that was going to be considered personal and substantial participation. And there are a couple of notes at the bottom of the slide that you can see. So first is there's no adversity needed. So even if you're joining an entity that is kind of takes the same position as your agency, you know, it still doesn't matter. The second is waiver. So in the model rules and some other jurisdictions, you're allowed to seek a waiver from the agency. In the DC rules, there is no waiver that allows you to be able to accept that client like it would in a 1.7 or 1.9 situation. And again, this also applies to individuals who may be at an agency but not acting as a lawyer. So if you're acting as a paralegal, or if you're in some other way, like a program specialist or something like that, this would also be applicable. Next slide.
We got a question in the chat. I think, did you guys want to hold all questions until the end, or should I?
Oh, no, they feel free.
Okay. Is there a time limit for former government employees on this rule, after which you, the lawyer, could accept the other employment?
So with respect to the rules of professional conduct, there isn't a timing requirement. I believe there is a timing requirement with Vega, but I'll let you guys talk about that. I was looking at one of your post-employment advisory opinions, and it was very thorough and illuminating, but I'll leave that to Asia or Raji to kind of go over. I'll just say, with the closing out my portion of this, so I can turn it over to you all, is that there are a couple of legal ethics opinions that provide useful guidance. And so you want to be able to look at those as well as the comments. I know when I was first starting in this position, even though I'd practiced for about 10 years, I was not very good at usually looking at the comments. And they are really helpful, as well as the legal ethics opinions. So I'll just make that plug. And then Asia or Raji, I don't know if you want to talk about the post-employment advisory opinions or any other rules or regulations.
Yeah. So this is definitely post-employment territory. So with regards to government employees, in the hypothetical, we had the attorney working at 2 different agencies. So it's important to note that the post-employment, the District of Columbia ethics rules would apply with regard to both offices that are referenced in the hypothetical. And so there's 3 main post-employment rules. There's what's popularly known as the cooling off period, and that's 1 year. And it says that for 1 year, you're prohibited from contacting your past agency with the intent to influence the agency. So you can't ask them to process something, you know, make a decision, take a certain stance on an issue, any of that. And you can't attend a meeting with your previous agency, even if you don't speak in the meeting. You cannot sign and submit documents to your previous agency. Signing and submitting a document is tantamount to representation for purposes of post-employment. And so for the 1 year cooling off period, you would not have contact. And for the purposes of the hypothetical, it'd be both those offices. And then there's a second rule that says for 2 years, if you had official responsibility over a matter, maybe you were a manager or a supervisor and you receive reports about a particular project or case, but you didn't necessarily get down into the actual meat of the matter, you'd be prohibited for 2 years from appearing as a representative on that matter. And you would also be prohibited from 2 years from appearing on a matter or giving behind the scenes assistance if you participated personally and substantially in the matter. And that kind of goes to the rules of professional conduct. And then final rule on post-employment is the permanent prohibition. And that is, again, if you participated personally and substantially in the matter, you are permanently prohibited from appearing in a representative capacity with regard to that matter. And so all of our post-employment rules are in the DPM, and it's Rule 1811. They are kind of complicated. It's a complicated area with regard to government employees. And so we always encourage folks to contact us. You tell us what you did at your agency, whether there were any details, if there's a second agency, your job duties, what you're going to go do, who you're going to go work for, and then we can give you detailed, specific analysis about any post-employment restrictions. We also have several post-employment advisory opinions on our website that speak to different things in the post-employment world. We have one general post-employment advisory opinion, and I do not know the advisory opinion number off the top of my head, but if anybody wants it, feel free to contact me after the course. And then we have another one that talks about personally and substantially, what that means. And then we have another one that talks about what a particular matter is. So to kind of help you and guide you, if you care about this or if you plan on leaving district government, or you should definitely read them.
Thank you, Asia. I was a little scared to unmute.
I can hear you now. I can hear you perfectly now. And it looks like we have another question. Go ahead. The question in the chat, how does that apply to other professions? Mental health practitioners, teachers, it sounds to me that it applies mostly to the legal field. I'm not quite sure which part of you were referring to. The rules of
Is this the question maybe about law-related services? I'm guessing.
Maybe. It was sent at 10:28.
Hi, this is Larry. So the question was related to not being able to be in a similar employment than the previous one with DC government. It sounded to me like it was mostly related to legal work. That's why I asked, how does that apply to other professions, like mental health practitioners, teachers?
I mean, for purposes of the rules of professional conduct, that's going to be mostly legal work. But for purposes of government ethics, that's going to apply across the board. And it's going to apply whenever you're exiting district government. Erica, did you have anything to add, Nikia? Rashi?
I didn't have anything to add.
No, that's good.
Okay.
Okay, next slide. So Angela is an attorney with the DC Department of Housing and Community Development. One of the officers, has asked her for an opinion on whether a proposed course of action is in line with their statutory authority. Angela has been tasked with researching and drafting a response. Based on the current state of the law, Angela concludes the office cannot proceed with the intended course of action, and doing so may harm the agency in multiple ways. Angela's boss disagrees and believes the agency can take the course of action, and directs Angela to draft a memo with his conclusion. What should Angela do? You can begin your answers in the chat, or you could feel free to unmute yourself. We have 2 Bs, 3 Bs, a lot of Bs.
Yeah, just see all Bs. I haven't even seen any other answer.
We have 1A.
1A, yep.
You're a brave man, David.
Yes.
Going against the grain.
Go against the grain, yep.
Okay, we can go ahead to the next slide. So the answer is B, diplomatically tell her supervisor no and give the reasons why. And so there are multiple rules that are really involved in this analysis. We'll start with 5.2, which is the subordinate lawyer rule, and essentially says a lawyer is bound by the rules of professional conduct, notwithstanding that the lawyer acted at the direction of another person. And then B, a subordinate lawyer does not violate the rules of conduct, professional conduct, if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. And so I usually try to simplify the rule to simply say, if it's clear what your professional duty is and your supervisor is asking you to act contrary to that, then you cannot do it. And so let's go to the next slide. So in this situation, you have multiple issues, 1.7b4 and 113. And so we'll talk about 1.7b4 first. And so the issue really here is whether or not Angela's professional judgment is being compromised in this situation. And then the second issue when it comes to 113 is that harm or not acting in what she believes the client best interest going to cause harm to the client. And therefore, if she continues on those course of actions, her professional judgment will be compromised, which is a violation of 1.7b4. Harm will occur to the client, which she knows what would happen, which would be a violation of 113. And therefore, it seems to be very clear, at least that's my position. Again, feel free to push back, jump in, and we can kind of talk a little bit more about it. It would be clear that if she kind of just went with A, which is do what the supervisor said, if she's correct in her analysis, harm would occur to the client. I don't know if Eric, you wanna.
Yeah, I'll jump in here because I just think this is a really interesting hypo, and I feel like it illustrates an issue that comes up a lot on the ethics helpline. And of course, there's no black and white answer here. A lot of times when people bring up these types of issues, they start talking about their professional independence of judgment, and that's sort of the worry. And it's funny, I didn't put the rule in here, Nikki didn't put the rule in here, that's rule 5.4, because if you look at that rule, which is titled, professional independence of judgment, it has nothing to do with that. It has to do with sharing fees with non-lawyers, right? It really doesn't get to the crux of that idea that as a lawyer, I have to make sure I'm using my good judgment and best judgment on behalf of my client. But and so instead, that's why we have these other rules like 1.7b4 or 5.2. There are going to be times when lawyers disagree about the appropriate strategy. And I think the question becomes, if I'm going into court and I need to make a statement such to the effect of, OAG's decision is that this criminal defendant is going to be charged as an adult, even though he is a juvenile. I might not like that policy. I might disagree with it. But if someone higher up in OAG has the authority to make that call, I probably am going to have to walk into court and make that statement. As opposed to, do I have to walk into court and argue that this juvenile's alleged crime meets X, Y, and Z standards such that he should be charged as an adult? And if I disagree with my supervisor on that, then that's probably a classic personal interest conflict. And it's those are very uncomfortable positions for people to be in, right? Where you're being told to go in and make an argument that you can't make because you strongly disagree with, the strength of the facts or the arguments that are being deployed or that you're being asked to deploy. And I think what I would tell somebody in that situation, that sort of second situation, which is like, look, at the end of the day, if you don't believe that there is a good argument or a valid argument that the judge should use his discretion to do X, Y, or Z on behalf of your client agency, then you've got to tell your supervisor, look, I'm not the right advocate. I'm not the right person to make this argument on behalf of the agency. I can't do it. I don't see it. I don't, you have the right to find someone else to do it, but I can't. And that, I think, is the classic example of a personal interest conflict, where you just have to sort of come clean and make that point. But again, that's a little bit different from the first example I gave, where somebody senior to you has the authority to take a position, which is a little bit more straightforward. And then you're going to probably be the mouthpiece, whether you agree with it or not. So I think this is just an interesting hypo. I think it comes out in a number of different ways. And I think one thing I would say to people who are in managerial positions is that when you kind of have a sense that you've got a junior attorney or someone that you're supervising who's feeling antsy, it's worth trying to hash it out and make sure that you can come to a resolution that makes sense to everyone, or, and maybe it's just giving the guidance, here's why I believe I have the authority to tell you to do this and that you must do this. Because it's protective of everybody if you can get on the same page with your employees, with the people that you supervise, in connection with these types of legal matters. But again, these are great calls to put to us on the ethics helpline as well, if you ever find yourself in one of these situations where there's a real sense of I can't do this, or can I do this, or should I do this?
And we could go to the next slide. I think this slide and the next rule 113 and 1.6 also illustrate, I think the answer A was, or one of the answers dealt with, can I go to the local news? Maybe it was C, and so we just wanted to also highlight the requirement that you report up and not report out. So a lot of people, if they, tend to get frustrated, we get calls often, I've reported up, I'm frustrated, no one's listening to me, what can I do? The option is not to go outside and kind of call the local news or something like that. You would look to Rule 113, which is, again, the report up, not the report out. I know that's different from the model rule and maybe some of the other jurisdictions. And then it's also further highlighted in 1.6. So I think that's the next slide. I don't know, Erica, if you wanted to add anything.
No, I think these are good points. These rules get really complicated, especially when we're dealing with government lawyers who in some situations I think are probably authorized by law to make statements or reveal information that lawyers typically wouldn't be authorized to reveal. But I guess in DC, we just remind people that the role of lawyer as a whistleblower is not a very comfortable one. It doesn't mean it can't be done, but it's not an easy thing to pull off, and it's going to require probably some consultation with an ethics attorney, with a professional responsibility attorney. And I think we would also say that the DC rule just reflects a belief that the lawyers are sort of their internal gatekeepers, right? And they can push and push and push their client to do the right thing. But for the most part, at the end of the day, that's where it stops. It's going to be more of an internal pressure. Again, unless in extreme circumstances, it's such that trying to go with a more nuclear option is appropriate or preferred. But it's hard. It's going to be hard to find a yes, you can do this in the DC rules. It's generally going to be some other outside source of law, or something else that would lead a person to ever go public with information that is confidential.
And there, I think it's important to highlight, there's a difference between, we have a difference of opinion, and there's just case law or statutory interpretation or something that just flat out says this is wrong. And sometimes that gets lost in translation with no, I'm interpreting this way and this is a reasonable interpretation of the law versus no, you cannot do this. And I just believe that it will harm the client 100%. In the interest of time, I think we had, the next slide was 1.6, but if we can just go to the next typo.
Right, so I'll jump in with this. So So Dave, Angela's coworker, explained that their supervisor has also been forcing him to push through agency initiatives, and they've clashed on the interpretation of certain statutes. Dave has anxiety and depression, and as a result of heightened tension with his supervisor, he has become dependent on prescription drugs. His doctor has stopped renewing his prescription, and he has trouble focusing and doing his work. Dave confides in Angela that just yesterday he missed a deadline. He is working to resolve it and doesn't want to say anything until he's sure it can't be fixed. Does Angela have to report Dave for missing this deadline? And we've got 3 possible answers. No, because he's working to resolve the issue regarding the missed deadline. Yes, because he missed the deadline. Or C, it depends. Look here at the chat and see what comes in.
Let's see. B. Oh, wait a minute. C. Mostly C. 1B.
Okay.
Yep. C.
And as lawyers, we've always been trained to select the most flexible option, which is going to be C, it depends, right?
Right. Someone said need more info about what was missed.
So, and that is always the case, right? So let's right. Let's go ahead to the next slide. So when we get these types of questions on the helpline, we have we have our standard disclaimer, which is that we give informal guidance on issues that arise under the rules of professional conduct. It's not legal advice. We can't give a safe harbor. And then we always say with these types of questions, and we cannot weigh in on whether another lawyer has violated a rule of professional conduct. We're not fact finders. That would put us in a very bad position. Inevitably, we will end up sort of discussing those issues around the edges. But it goes to the point that was made in the chat that, well, we need more information, and that's probably true. So my starting point with this hypo is we know that there's a missed deadline. Absolutely, I'm probably going to suggest to a person, well, what kind of deadline was this? Was this a discovery deadline, which I think generally carries an awful lot of flexibility? Was this the deadline for getting a motion for summary judgment in? Like, what are we talking about here? And all of that goes to the fact that one must make in order to have a mandatory reporting duty that another lawyer has committed a violation of the rules of professional conduct, right? Because that's what 8.3 requires, the actual knowledge of violation of the rules. Those are actually pretty high bars. Both of them independently are high bars. Furthermore, it has to raise a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So what does that mean? I mean, these are really interesting discussions to have, and like anything, you can often analyze questions both ways. But the fact is, lawyers violate Rule 1.6, which is the duty of confidentiality, all of the time, right? They send an email to the wrong person. They drop a memo on the ground that's sensitive. They're overheard saying something and they accidentally use the client name, right? You can turn that into a crisis, or you can kind of look at it like, look, depending on the facts, let's not pretend that this, the fact that this happened, that another lawyer did this, a lawyer in your firm or a lawyer that who's a neighbor or something like that, it would be absurd to turn that into a mandatory reporting situation just because you knew that the violation had occurred. So here, with the hypo that we've just been talking about and the missed deadline, again, I don't think Angela knows enough to think that she could have a mandatory reporting duty here. Let's go to the next slide. I'll also make the point that the fact of a substance abuse or a mental health issue does not standing alone indicate that an ethics rule has been violated. If we're being realistic, there's an awful lot of lawyers who have substance abuse issues who are actually very competent, high performing attorneys and individuals, right? They carry on in a very functional way despite having a substance abuse problem. It's only when that lawyer actually violates a rule or fails to meet an obligation to a client that you have to start considering whether a rule has been violated. So here we know that a deadline has been missed, but we don't know what it is. I think if I were Angela in these situations, I'd be telling my colleague, look, it sounds like you're following up on it. Just make sure you do, and make sure you let someone know if this can't be fixed, if you can't repair the situation. Rashi or Asia, do you have any internal guidance for DC government that you use in these types of situations?
No, but I know she was having issues with her audio. Do you want to respond in the chat about this? The only thing that will really come to mind is just that, district service is a public trust. And so a district government employee's first loyalty has to be to the rules and laws of the district and put in the best interest of the district government first. And so that's really the only thing that would come up. But for something like this, we would most likely classify this as a personnel issue or professional conduct issue.
Right. So the few more things that I always will mention when we're talking about this kind of hypothetical is that we talked about mandatory reporting, right? Which is when you actually have a duty to report another lawyer's misconduct. Of course, in the DC rules, we also have permissive reporting. And that just means that a lawyer who in good faith believes that another lawyer has violated the rules of professional conduct has the right to make a report to the Office of Disciplinary Counsel because it's not being done in good faith. The only limitation, of course, would be that person cannot use confidential client information in making that report voluntarily. Other ways of addressing issues like this, and these would probably be the preferred options in these circumstances, because again, we haven't identified a clear ethical violation. There's Rule 113, right? Reporting up internally, under Rule 113B. Rule 5.1, Rule 5.2 just talk about the general obligations of a supervisory lawyer or a subordinate lawyer. I think in this hypo, we set them up as colleagues as opposed to one having supervisory duties over another. But if that relationship had changed, then our analysis might have changed here. Lawyers always do have to remember that in DC we have 8.4G, which says it is misconduct to seek or threaten to seek criminal charges or disciplinary charges solely to gain an advantage in a civil matter. Again, it's not like any of those factors are in play in this hypo, but we do tell people, if you think you might have an obligation to make a report on a lawyer, it's almost never a good idea to go and tell the lawyer that, because that can be perceived as a threat. And of course, we have the DC Bar Lawyer Assistance Program. That again, if we got this hypo on the helpline, we'd probably tell the lawyer, Angela, why don't you call the Lawyer Assistance Program and talk to one of the counselors and see if they can recommend a way for you to reach out to your friend and tell him what sorts of services are available. My alarm went off, and that's because I'm supposed to give a code for CLE, and I'm going to announce it. It's BG74. Again, BG74, and I'm supposed to display it here. I don't know if that's going to work. BG74.
Are you able to put it in the chat, Erica, or did you want me to do it?
Yeah, why don't you go ahead and put it in the chat? I think that's fine. I know that's important.
We got a question. It said, where do we enter it? I believe everyone will be getting an email, right, in the next couple days?
I think that's correct.
Yep, you'll get an email and you'll have to complete the requested information in the email, which will include the code. Someone asked if this is a CLE approved in Virginia, and yes, it is.
Yes. The Virginia deadline is coming up, I know.
We got a actual question relevant to the hypothetical. I think.
Yeah, I'm just trying to pull this up right now. Would you cover dealing with harassment? You know what, Nikia, what do you think about skipping through to the very last slide? We've only got 5 minutes left. If we can.
Yeah, since this is relevant to 8.4H.
Yeah, so I'm gonna put this forward. I mean, it's both mandatory reporting and it's sort of specific to harassment. So Asia, if you would go to the very last slide.
Is this a, or you want to skip?
Actually, even beyond, oh, even beyond this, it should be the very last one. Discrimination, harassment. Okay, this we put in here not as a hypo, but just as an update. But give me 1 minute. I just want to pull down the chat questions too to make sure I'm dealing with harass online after. Okay, so this might not be directly relevant because it sounds like this is almost a question about I'm getting retaliated against.
Yeah.
Right. I'm getting an adverse action. That sounds to me like an employment law question. Maybe there's an ombudsman, within the DC government agency that you work for. It sounds more like an HR type problem, because the DC rules, they do not provide any sort of protection for someone who's making a hard decision under, with respect to a duty to report, or a decision to withdraw from a matter. The reward is complying with the ethics rules, and I know that's a cold comfort if you're dealing with some negative blowback from that. But because
Erica,
yeah,
when I read it, it sounded the second time. It sounded like maybe are you asking if you can reply to someone online who's harassing you online? Because we do have those ethics opinions that deal with, but. Maybe the person wants to unmute themselves.
Nakia, you are in the right track of thought.
Okay.
So it is when let's say, like a lawyer with the government comes up with a decision, or a judge, or a decision is made, and then there is either retaliation or harassment online. Now that we live in a virtual world, would that lawyer or that professional go back to their body that, like, for example, mental health practitioners have American Counseling Association, lawyers have DC Bar, or would they go to BEGA, or all of them for the matter, for counseling or guidance on or how to manage it, etc.? And I understand not to engage, of course, because that would be the biggest no-no from my perspective. But what else can that person do?
Yeah, I don't think Vega would have the space for that. I will say we do have retaliation protections. But that is only for those who have reported a matter to our office or to the OIG. Because you have an affirmative obligation to report. So if you do report, we do shield you from retaliation, and we take retaliation really seriously, but it's not a blanket cover for retaliation. So I think in this scenario, you would only be relying upon maybe other general protections from harassment or bullying or retaliation, but not necessarily government ethics.
right. I think that's good advice. I mean, we have, and like Nikki already mentioned, and you mentioned, there's very limited things you can do to defend yourself publicly when you're getting harassed for taking an unpopular position, let's say, on behalf of your client. I mean, and that can put lawyers in very uncomfortable positions. But I think the guidance that is going to serve you best is probably more of a practical nature, which is going to be, delete some social media accounts, things like that, as opposed to, being able to look at the ethics rules to find ideas. Again, you can always call us, because, we can sometimes point to provisions in Rule 1.6 that might provide a very limited opening to to make some sort of statement defending yourself. But this sounds primarily to me like a, more of a practical or an HR kind of solution as opposed to an ethical one.
We had another question in the chat. One moment. If we can ask ethics questions that have not been covered in this presentation, I have the following question. What are the rules and limitations regarding government attorneys volunteering for political campaigns outside of the District of Columbia? Are there any limitations outside of prohibiting volunteering during work hours and making sure you are there solely in your individual capacity?
Asia, I'm inclined to leave that for you. That sounds like a Hatch Act question. I don't know.
It is a Hatch Act question, and I will say that the Hatch Act applies across the board to government employees, so there are no special rules or laws that apply just to attorneys, so the same restrictions. Another question, how do you recommend dealing with, for example, a written communication from opposing counsel containing racially discriminatory language? That might be more, Erica, that may be more professional conduct. We wouldn't have anything for that. I know people contact us all the time about, somebody used profane language or racially discriminatory language. We do have the Office of Human Rights that may be able to address some of those things. But there also might be professional conduct rules that
There are, and I mean, I don't know, we're already a little bit over, so I don't know how much time we want to take. We currently have 2 rules addressing discrimination and harassment that apply either in the employment context on the one hand, or when you've got a matter that's pending before a tribunal and it's in connection with that in some way. This slide that's up right now shows a new rule that has been proposed by the DC Board of Governors to the DC Court of Appeals that is going to be broader than either of those 2 rules. So this is not in effect now, again, and we don't know when or if the court will act on it. This is modeled after the model rule, which was adopted back in 2016, and only a limited number of states have adopted it thus far. But I guess maybe what I would suggest is that it is a good call for the ethics helpline if you wanted to chat with one of us, because the remedies now are going to be probably just reporting to the Office of Disciplinary Counsel, if you can come to the conclusion that the conduct would violate either 9.1 or 8.4D.
Okay. All right. And so that brings us to the end of our presentation. And we thank everybody for your attendance. And everybody should be on the lookout for their email to get their CLE credit. Is there anything else that I'm missing with regard to the CLE credit, Erica, that I should mention before?
I don't think so. So it's that, that BG74, and that should be that's the code you need.
Great, thank you. Would we have access to these slides later?
Yes. Yep. All
Thank you.
Ethics Week presentations will be posted on bega.dc.gov. And I believe that all of the resources and opinions mentioned by the DC Bar are available on your website, right?
That's right.
All
Great,
right.
thanks so much.
Thank you all for attending. Bye-bye.